And good afternoon. I'm Attorney Michael Bender.
And I'm Attorney Allison Tilton, and we are the Gray Legal Group.
Welcome to this week's Ask a Lawyer on Facebook Live. I'm excited today.
You're always excited.
Well, no, we have a theme.
We do have a theme.
In my never-ending quest to bring order to chaos, we've put together 3 fantastic questions all around the house. You excited?
Yes. The house.
Before we start, though, the information in this video is for general information purposes only. Nothing should be taken as legal advice for any individual case or situation. The information does not intend to create, and receipt of viewing does not constitute an attorney-client relationship. Let's get to the houses.
Let's get to the houses.
Who was?
I will. I'll start
Okay.
with the question.
There we go.
Okay. First question we've got. Can I take my kids with me if my husband kicks me out of the house? I'm divorcing my husband. Up until I came home late after a night out with friends, we were civil. After that night, he threatened to beat up my friend and told me to get out of the house. Do I have a legal right to bring the kids with me?
Okay, I think in this question, I'll go ahead and take the first part of this question, kind of like we practice.
We practice a little bit, not that much.
Really, the question here is putting the cart before the horse. My husband kicked me out. We're going to make an assumption here that the husband and wife own the house together or on a lease together, and you both have the right to the house. Husband can't kick you out just because you're separated or you're getting a divorce. He can't just say, "Well, you spent, spent a late night out with a friend." I'll use air quotes there. There's no legal right for one spouse to say, "Get out of the house." Really, though, my concern with this question is that he's threatening to beat up the friend. If there's an issue of potential domestic violence, don't be posting questions, don't be calling friends, don't do anything, do not pass go, do not collect, do not collect $200, something like that.
Yeah.
Call the police if there is a potential of domestic violence. At any point in time, get law enforcement involved, protect yourself, protect your children. Once that is accomplished, then contact an attorney or go to the Family Law Assistance Center and potentially file for domestic violence restraining order. That's a serious note on this one that I pulled out of this. Do you want to talk about the kids?
Yeah, the last part of the question is regards to the kids. So whether or not there is a valid kick out, which doesn't sound like there could be based on Michael's assumptions, but if you were to leave with the kids, or if you were to leave the house, can you take the kids with you? Before you've got custody orders in a case, you know what? You both have complete equal rights to the kids. You can absolutely take those kids with you, but just so you have a heads up, husband is probably going to file an emergency action with the court regarding his rights to visitation with the kids. Like I said, you both have equal rights to the kids unless the court determines that you don't have equal rights to the kids. So if you've got a legitimate reason to take your kids because of their safety or there's just some other concern relating to the kids, go ahead, take the kids out of the house. And then you may have to deal with the consequences of an emergency hearing. But if you do not have a legitimate right to take the kids with you, like you're not legitimately concerned for their safety, then just be aware that the court might view you as withholding the kids from dad, and then you might have problems with custody visitation down the line.
Very good. Okay, second one.
Thanks.
Yeah, I'll go ahead and ask this one because you practiced this one.
I did a little.
Can I have the locks changed on my house when my spouse moved out? Kind of talking about kicking out and possession of the house, but shoes on the other foot here. I purchased my home 5 years ago, got married 2 years ago. The house is in my name alone. My spouse has lived with me the whole time. She moved out recently and rented her own place. Can I legally change my locks to prevent her from coming and going while I'm not at home?
A quick answer to this would be, yeah, you could absolutely change the locks to the house. In this question, you purchased the house prior to the marriage. That would make the house your separate property, assuming that you never did any type of transmutation or conversion of the property during the marriage to community property. It's your separate property. The other spouse does not have equal rights to the property. Once they're out of the house, you can change the locks. You don't have to give them a key, and they can't just come onto your property. Anything to add?
No, I'm good. I'm good with that.
All right.
I would give the same advice.
All right, that's good. Okay, let me
Final
go
question.
ahead. We've got third question today. Does the court see a parent who is married and a homeowner a better fit for custody? My child's father and I divorced, and I got full custody because he didn't want to go to court. He just signed the judgment. Last year, he bought a home and we will be, last year he bought a home and we'll be getting married next year. Okay. X is getting remarried. You're not getting remarried. He's getting remarried. He's threatened to take me back to court, saying he will get full custody because he is married and owns a home, and I'm single and live in a mobile home. Does the court give preference to a homeowner parent?
Underlying question here, because of course as lawyers we always see the question that isn't there. But underlying question, no. When looking at where a child is going to reside, the court's not going to say, oh, you have this beautiful, glamorous home, just because of that, you're going to receive custody. The court's going to look at a number of factors and really determine what's in the best interest of the child. Now here's the question that wasn't asked, was with regard...
I'm not sure you answered the question that was asked. Sorry. They already have a judgment in this case. There's already custody orders. And the child appears to be living in the mobile home right now, and now husband is buying a house, and she wants to know whether or not the husband's going to get preference because he lives in a house over her.
Correct.
And you've got custody orders in place. There is no preference given to the type of house that somebody lives in determining the custody orders. So I think you were answering the question if they didn't have custody orders.
Even so,
Okay.
Regardless. But the question that wasn't asked actually goes down, does relate to the fact that a judgment is already entered.
Okay. A modification of the
A
custody
modification. Is that enough to qualify for a modification of the custody visitation? Really, there's going to be a lot of other factors that are dependent upon it. What were the factors that, was he renting a home at the time, renting an apartment? Was he living in a mobile home too? What are the changes in circumstances? But quite frankly, moving into a larger house when mom has had full custody this whole time in a mobile home, it's really, in my opinion, would be disingenuous for a parent to go in and say, well, I have a better house now. That house is no longer good enough. That mobile home is no longer good enough, even though it's been good enough for the past couple of years in this situation. So.
Absolutely. All right, well, I think that about wraps up this week's Ask a Lawyer.
Did we bring order to chaos?
I'm not sure we did, but I think maybe a little. So thank you for joining us on Ask a Lawyer. Join us each week when as we discuss the family law issues important to our community. If you have a legal question or topic you would like us to address, go to thegradeLegalGroup.com and click on Ask a Lawyer. We'll see you next Tuesday at 1:30 p.m.